Park's webinar, which is about the rules for payments in construction contracts. I'm Cathrine Ripley, and I'm joined today by James Palmer. We're both partners in FSP's construction team. Before we get started today, I've just got a few items of housekeeping. Firstly, this is a live webinar. We're not expecting any technical problems, but please bear with us if there are any, and we'll try and sort them out as quickly as we can. We're scheduled to run for about 30 minutes, and we'll try to keep to time. We've put everyone on mute, but there is a box which you can add questions in, and we'll try to go through as many of those as we can at the end. If we run out of time, we'll follow up any questions we haven't answered on a one-to-one basis offline. James will be running a couple of polls during the webinar. Please do participate in those. We'll send out a copy of the webinar and the slides afterwards. And finally, there'll be a short survey at the end of the webinar, and really appreciate your feedback on today's event. So I think that's everything. James, would you like to just kick off by sort of summarising what we're going to talk about today and why we thought this was an important topic to cover?
Well, it is an important topic because although it sounds very technical, it's absolutely payment is obviously the lifeblood of any business, particularly construction businesses. So say we're going through rules which will make sure that either cash flows to the right place or stays in the right place. And the topic is so important because depending where the cash is whether your business success is a success or a failure, as we know. In 2023, this is a sobering statistic, 4,500 construction businesses went insolvent because of poor cash flow. So the topics we're going to be covering today, as you can see on the slide, are what is a construction contract and why it matters, what are the rules, minimum requirements required under the law, what is a smash and grab and how to avoid it, and we'll also be going through the consequences of not following the rules, and we'll round off with some of the latest developments in the law which you might find helpful, and some practical advice for whether you're a contractor, an employer, or a contract administrator. So we're going to start, as in the tradition of anyone who watches Who Wants to Be a Millionaire, we're going to ask the audience a question on our first poll question. And here it is. And it says, what was the top cause of disputes in construction contracts according to the King's College London CERT 2024 study? And you should be able to choose between one of those four options, which are either exaggerated claims for payment, personality clashes, inadequate contract administration, or lack of competence of project participants. So as I say, and if you can vote now, see what you think is the right answer. Oh, and the top answer we've got here is inadequate contract administration. We obviously got a very switched on audience this morning because that exactly was the top answer. Over 50% of the participants in that poll said that contract administration or inadequacy of it was the top cause of it, followed closely by lack of competence of project participants. So so obviously we've got an educated audience here, Cathrine. So what is a construction contract?
Yeah, so against that background, it may be that some of the sort of problems with contract administration arise from those parties that get into difficulty not sort of being fully aware of the rules, and it's no understatement to say that they are pretty involved, and we're going to try and sort of do a bit of an overview of the key features in the next section of our talk. The first question is, what is a construction contract? And this really matters because the Construction Act applies to construction contracts, and in particular, given what we're concerned about today, the rules around payments under construction contracts only apply to construction contracts. So if you haven't got a construction contract, no need to worry. That said, a construction contract is defined as a contract for construction operations, and construction operations is very widely defined. So, for example, a contract for surveying services or a labour-only contract have both been found to be construction contracts. Another one is work under a subcontract or a settlement agreement, which varies. A main contract or an original contract has been found to be sort of part of a construction contract. I had a case not so long ago for a client who designs and manufactures hydrogen refueling equipment, and they were involved in negotiating a particular contract, and because of the extent of the installation works and associated kind of construction works that were involved in supplying this particular piece of kit, that was a construction contract, and so all the requirements of the Act needed to be taken into account in the payment clause. And if the requirements of the Act when it comes to payment provisions are not included in a construction contract, then the Act provides that the provisions for payment in Part 2 of the Scheme for Construction Contracts, which we'll refer to as the scheme, will be implied into the contract. So it's important that once identified that this is a construction contract, that the payment clauses meet the requirements of the Act, otherwise the scheme requirements will automatically apply. If we turn to the next slide, Shannon. Would you like to just sort of expand, James, a little bit on why this kind of set of rules have kind of come into place?
Yes, I mean, this is established in the 90s because clearly there was a problem with payments going to contractors, and they wanted to keep money flowing through the industry. And so the theory behind the payment rules was summed up by a well-known construction adjudicator as pay up or pipe up. So the important thing is once a contractor has asked for payment, an employer has got to respond promptly and not stall as to what they want to do, either accept it or not. So there's meant to be short time frames with interim payments to keep money flowing, and clauses like a contractor only being paid when the employer has been paid or so on have been stopped. So Catherine, that's the theory behind it. Perhaps you can go in, what are the requirements for the basic rules for payment and the consequences of them?
Yeah. So there are various different requirements, and I'll just do a real sort of whistle-stop sort of summary of the key bits. Basically, the Act says that a party to a construction contract has a right to stage payments, and if the contract is silent, the scheme will imply stage payments into the contract based on the value of the work carried out in the relevant period, which is sort of consecutive periods of 28 days. So a contract needs to have some sort of instalment payment mechanism. So, for example, the JCT has two options: either interim payments at monthly intervals or a specific payment schedule for certain amounts to be made at particular times. A specific payment schedule does come with some potential for problems. For example, if there are errors in the payment schedule, the courts won't necessarily intervene to correct them. And if the payment schedule is for a limited period of time and the work actually overruns that, the contractor may find that they're not entitled to any further payment until practical completion, as was the case in one decision involving Balfour Beatty. So there's got to be some sort of payment schedule to deal with the periodic payments. The contract needs to specify the due date and the final date. The due date, as it sort of says on the can, is the date when the payment becomes due as per the terms of the contract, or if the contract is silent, as per the terms implied by the scheme. And there also needs to be a final date for payment. And this is really a long stop date. It's a bit like a contract which states time for payment is of the essence of the contract. It basically means that the consequences of non-payment ramp up if payment hasn't been made by the final date. We'll come on in a moment to timescales, but just going through now the different kind of documents that will ordinarily be produced as part of the sort of payment terms, and these are the things that broadly are required by the Act, or typically required by many standard form contracts, such as those published by the JCT. And the first item on my list, applications for payment, are not something that actually the Act or the scheme require, but contracts like the JCT recognise that it's the application for payment, which is the usual document which is produced by the contractor to trigger the whole start of the payment process. That's usually then followed by an interim valuation made either by the employer or the contract administrator, employer's agent on the employer's behalf. Some contracts will actually require the interim valuation to sort of meet the requirements for a payment notice. But in any event, the rules require, whether or not there's been an interim valuation, the rules require the employer to serve a payment notice, and that's sort of an important first document from the perspective of the rules. And it needs to specify the amount which is due at the due date, and that's referred to as the notified sum, and how it's calculated. And it can't be stressed that the payment notice must be really clear and unambiguous. Both the fact that it is a payment notice, and that can either be made on the face of the payment notice itself or in, say, the covering email by which it is sent. And it also needs to be very clear in terms of its contents. Now, if the employer fails to serve a payment notice, the rules allow the contractor to serve a default payment notice. In practice, if the contractor has made a payment application, which in most cases it will have done so, this will then operate as the default payment notice. The default payment notice needs to meet the same sort of requirements as the payment notice, i.e. it must specify the notified sum, that's the sum due as at the due date, and be clear as to how that sum has been calculated. The notified sum, whether it's set out in the payment notice from the employer or the default payment notice from the contractor, must be paid by the final date unless a payless notice has been served. A payless notice is a notice sort of explaining why part of the notified sum is not going to be paid, and it needs to meet the same sort of requirements as payment notice or default payment notice in terms of the amounts that it's referring to and clarity as to their calculation. The time frames for serving these different notices are very strict, and so as well as actually getting the content of the notice right, it's also important to comply with the timeframes for serving the notices. Because if the employer fails to serve, hasn't paid the notified sum by the final date for payment and hasn't served a payless notice, then the contractor may suspend work and go to adjudication. And that applies also if the employer hasn't made payment and has purported to serve a payless notice, but it's defective. So the contractor would still then be able to take action. If we can just move on to the next slide, we can explain a little bit more about the timescales. We've tried to sort of do this little flow chart to try and summarize the different stages and the timescales between each stage. And as you can see, many of the timescales are the same as provided for by the scheme and in the standard JCT clauses, although there are slight chain differences at some points. The Construction Act allows the parties to flex these timescales a bit, provided that they follow the Act's basic mechanism. But if parties are going to agree longer periods of time, it makes sense to be reasonable in terms of what you're agreeing. If you agree to very long, outlandish periods of time, that probably increases the risk of some form of challenge. And that, I think, James, brings us on to your second poll.
Yeah, it's question time again. And question is, what type of claims are the most commonly referred to adjudication, according to a King's College London survey, again, of the construction industry in 2024? So we have four options there. It's either seeking an extension of time, or a value of the final account, a termination of the contract, or a smash and grab or technical payment claim. So if you could vote now, and we'll see. And again, it looks like the audience is paying attention. So half of them anyway, to say that 50% think it's smash and grab, and they'd be right. In fact, nearly 2/3 of all claims referred to adjudication are on so-called smash and grab. So if we turn to the next slide, then we'll see what on earth is smash and grab. So basically, it refers to a claim based on a technical breach of the payment rules, which Cathrine has just outlined. Either normally it's just someone not being on top of the time deadlines for serving notices. And so a smash and grab really is the consequence of getting that wrong. And where say a contractor can apply based on their payment application and just merely on a technicality for the employer failing to serve or contract administrator failing to serve a payment notice or a payless notice could mean that the contractor is entitled to be paid more than, even if it doesn't reflect the so-called true value of the work done. The other potential consequence of getting it wrong, and as the smash grab, of course, is that if an employer still refuses to pay the sum awarded, the contractor may enforce or indeed suspend work under the contract or under the law. Another unpleasant side effect of a so-called smash and grab is that a losing party may have to pay an adjudicator's fees and its own costs for dealing with the issue. So really, it pays to be on top of the rules. So what are the key things that a contractor should remember then from all these rules? And we've got a list of those on the next slide. So quite a lot of this, I think, is common sense. But first one is, when you're at the outset of a contract, try to agree the interim valuation dates and payment due dates, final dates of payment, and then diarise those on all your payment systems, so that it is flagged up. Secondly, make sure that any payment application is clearly labelled as such and sets out the sum you are claiming and how it is calculated. And thirdly, always check on the contract to whom the payment application should be sent and by what means. Quite often, some payment applications have been ruled to be invalid because they haven't been sent to the right person or to the right email address or to the right recipient. So it's always important to get that clear. And what are the key things for an employer to remember, which is on the next slide? If the contract requires it, like a JCT contract, appoint a properly qualified contract administrator, or sometimes known as an employer's agency, on a design and build JCT, and then, just as importantly, resource them to do the job. Quite often in my experience, in some of the disputes that I have to advise on, some of the troubles have arisen because the contract administrator has been too thinly stretched on other matters, or hasn't been given enough time to undertake their role. Of course, you may be in a scenario in the smaller contract, or one where you're not using a standard form, where there is no contract administrator. Just appoint someone internally to be responsible for dealing with payment issues and monitoring progress for works. Now, most employers do this already, but I still see cases where they haven't been, someone hasn't been appointed, or someone was appointed then left, and then no one else is then in charge of the scheme. And then finally, just like contractors, do ensure that your key dates again are diarised on your payment systems, and that you check the validity of any payment applications you receive, because you maybe have grounds to reject a payment application. And then, of course, the final, we mentioned them quite a lot, is contract administrators and their role. So if we turn to the next slide. What's their role and what must they do? Well, ultimately, they must assess any payment application, interim payment application that's come in, and then issue a payment notice. Now, they have a duty to act impartially, and this has quite a wider ramifications, doesn't it, Cathrine?
Yeah, because although the contract administrator or employer's agent will be appointed by the employer, they do have this duty to act impartially when they are making interim valuations, among other things. And it can sometimes be easy for the employer in particular, given that they have appointed the employer's agent or CA to forget that. But the importance of impartiality is highlighted, particularly where, for example, you have a contract administrator, QS, cost consultant, whatever, who is required to give collateral warranties to third parties, such as the employer's funder, where that duty to act impartially really matters.
And also, they've got to act promptly. So particularly on valuing interim payment applications, it's better to make a quick, imperfect decision, which might be out very slightly, than trying to make a perfect one, but you're out of time, because then you're lumped to the employer with having liability to pay much more money than they might have to if they've done a true value evaluation.
Thanks. We're running on quite well, but we will sort of try to wrap up our final few slides and then take a few questions. We've just got a couple of sort of recent developments that we were going to mention quickly. So if we can move on to the next slide. What's happiness? That was James's corny title, but it highlights the fact that parties, as well as complying with all the rules that we've been talking about already, need to be careful when they come to some of their communications. All areas of the law can sort of be vulnerable to informality causing problems, and it's all very well as lawyers talking about doing everything in accordance with contract procedures, but you know, practice doesn't always follow theory, and perhaps no more so than in the construction industry, where people are often working on the go, not necessarily at their desks doing their jobs. As I've already touched on, the payment rules are not straightforward, and there can be pitfalls at the best of times. So one does also need to remember to be careful about using mobile communications, whether that's text messages, WhatsApp, or anything else. There was one recent case where some invoices were sent by WhatsApp, and that was found to constitute a valid payment application. So one does need to be careful where you're using informal means of communication, and it might also be sensible to look at the contract and consider whether, when you're negotiating the contract, whether it makes sense to allow or disallow certain types of communication. I think then, James, you were going to talk briefly about the Procurement Act 2023 and how that kind of impacts on these rules.
This is particularly in relation to anyone that does work in the public sector. So a new act came into force in February of this year. The Procurement Act, it modifies some of the payment rules that automatically apply to any sort of one that's working in the construction and public sector. So these are the key ones here. So an employer must accept electronic invoices from a contractor or supplier, and then most relevantly, it says that any sum due must be paid within 30 days of receipt of a valid and undisputed invoice. So there's a query about what might be a valid and undisputed invoice, but if you are an employer and you receive an invoice from a contractor, you have 30 days in which to raise an objection, as in a payless notice. And you should make sure that if you are operating in the public sector, that your payment terms in your standard form contracts reflect that, otherwise you may not be compliant. There's one query that you should, I think, should be aware of, is a payment application that we've just been talking about, is that the same as an invoice? Because often the practice is that a contractor and an employer would agree the sum due after a payment application, and then an invoice is issued. However, there is some doubt about whether a payment application is the same as an invoice. So therefore, our advice would be to treat them as the same and make sure that you get your objection in by way of a payless notice within the 30-day period of receiving a payment application.
Thanks, James. Would you like just to move on to the next slide to wrap up with our sort of top tips for avoiding a smash and grab, or to benefit from a smash and grab if you're a contractor, and then we'll take a few questions.
Yes, that's where we're just on the half-hour mark. So very quickly, So our top tips, really, just to sum up what we've been talking about this today. Agree the valuation dates with other parties to the contract and stick to them. Again, in many of the disputes I advise on, it's people start off with good intentions and then they drift off, and then later on there's a dispute, then you're in some difficulty. So stick to these dates, diarize them on your business systems. Be clear on the requirements for the form of the payment application and the information that needs to be put on that, and so as well as with the payment notices and pay less notices. A good tip is to follow either the template set down in the contract or JCT or REBA, and I think some other bodies issue templates, and if you follow those, I don't think you can go far wrong. Check the service requirements in the contract, i.e. where do you send notices to and when, and follow those, and again make a note of those on your diary. And then finally, follow the 3 R's, which is records, records, records. Just keep a record of payment applications, how they've been calculated, so you can be ready to prove the work done and your assessment. And so that is really, something to take away today.
Yeah, I was just going to add in relation to your point about record. Obviously, if you're making payment applications via WhatsApp message, as I mentioned earlier, that could be a problem because the WhatsApp message gets deleted, then there's no record of it.
Exactly.
Anyway, we just move on and take a few questions. We've got one question here, James. Sounds like it's come from somebody who maybe has sort of had an experience where they've paid too much to the contractor and then had a smash and grab adjudication application. What would be your suggestion there? Is what you could do as to what they could do?
Well, first thing really is to try and negotiate with your contractor employer, and because there will also be another interim valuation date coming along, and if the employer is switched on, they will be able to then serve a pay less notice and reduce the sum that might be due. That's one option. The other option, I mean, if it's a significant amount of money, is to launch what is called a second adjudication, called a true value one, and ask an adjudicator to rule on what should be the true value of the works done, and not just based on a technicality of have the notices been served in time. So, but that's a much more expensive and time-consuming route. So obviously the best thing to do is to avoid being put in that position in the first place.
I've got another one. What can the employer do if they don't agree with contract administrator's valuation?
Well, it's unusual, but I have seen a situation where an employer has served their own pay less notice. So you can have the situation where contractor applies for, say, oh, I've done work for £1 million this month. The contract administrator, who may not be, again, might be not to have looked through the application in detail, or not being able to, said yes, signs that off, and then the employer or someone on the ground says, well, actually, they've only done £500,000 worth of work. So the best thing to do in that situation is for the employer to serve a pay less notice in time and the deadline, and then they will not be liable to pay the application, but only the sum as admitted in the pay less notice.
Right. Okay. Thanks. We're sort of over time now, so we'd better bring this to an end. There's a couple of other questions I see. We'll follow up with those on a one-to-one basis. And if anyone else has got any questions, please feel free to sort of put them in the chat or contact us afterwards. We've got a slide here just to sort of mention a few upcoming events from our commercial property team and our employment and immigration team. If you're interested in any of those, please do register and join us. I think that just leaves me to say thanks very much for attending. I hope it's been helpful. If you do have any questions or other follow-up, do contact James or me. And if you've got a moment just to very quickly do this feedback survey before you log off, that would be much appreciated. Thanks again, and enjoy the rest of your day.
Thanks very much.
Thanks.